It might be based on skill, experience level. Those sorts of things would be objective criteria that move you away from those risk factors. That's where we really want to get into sort of clear-cut, objective decision-making that mitigates that risk.
Workplace law is complex and constantly changing. It can be hard to keep up, and the risk of getting it wrong can be costly for businesses. The Coffee and Law podcast is here to help HR professionals and employers stay informed. We'll cover what's changing and how to navigate real workplace situations and everyday people decisions. So grab your favorite warm drink and join us for engaging, practical, and educational conversations with top experts in workplace and employment law.
This podcast provides high-level general information. The perspectives shared by our guests are for educational purposes and do not constitute legal advice. If you have a specific question or concern, please consult a qualified lawyer.
Hi everyone, it's Amy Davies, founder and CEO of First30, and also your Coffee and Law podcast host here, to remind you that First30 offers career transition and outplacement services. So if you have terminations and layoffs coming up, this is a really good way to mitigate risk to your business and help your exiting employees recover from the job loss and get back to work. You can find out more information at www.first30ready.com/outplacement, or you can reach out to me, Amy, AMY, at first30ready.com. All of our programs include live coaching and a year of access. And in a tough job market, that can be very important. Now, back to our show. Hello and welcome back. If you are returning, we have several returning guests I've noticed, which we always love, or listeners, I should say, but I kind of feel like you're guests. I feel like we're all kind of sitting together having a chat each episode, but thank you so much for joining the Coffee and Law podcast. I'm Amy Davies. I run a business called First30. We do outplacement and onboarding. And for those of you returning, welcome back. And I'm very excited to be joined by Ashley Brown today, and I'm going to introduce her in a second. But I first wanted to thank our partners, HR Law Canada. I know they have a lot of articles on the subject that we're going to talk about today: restructuring, terminations, layoffs. And they have a lot of great articles, and they do follow a lot of case law, which can be very interesting as well. And also, as always, thank you to our producers, Storyfora. And if you are tuning in, we would be so grateful if you subscribed to the channel, if you're on YouTube, or give us a 5-star rating if you're listening on audio. It goes a very long way, and I really do appreciate we've been getting a lot more subscribers, so that's been amazing. So Ashley, I'm very excited to have you today. Ashley and I have known each other and of each other for quite some time, but we met very recently at Social HR Camp.
That's great.
And in Kitchener-Waterloo, where we were both speaking, actually, and you gave an amazing talk on workplace investigations. Unfortunately, I don't think we have the whole talk filmed. I don't remember seeing that, but it was such an excellent talk. I learned a lot, and that's obviously something I followed, especially over the past year as I've had this podcast. But we're not here today to talk about we're not here to talk about workplace investigations. We're here to talk today about restructuring, terminations, and layoffs. And I know that you help a lot of clients. So Ashley is with a law firm called Filion Wakely. Have I got that right, Ashley?
You nailed it. Thanks, Amy.
Yeah, thank you. So Ashley's with Filion Wakely, and I know that it's a lot of your work. And I was actually looking, I'm part of the People group on a Slack channel, and I was just seeing some questions today about terminations and layoffs that I'm interested to get your perspective on, Ashley. But why don't you tell us just quickly a little bit more about you, your law firm, and the work that you do?
Yeah, absolutely. Well, first and foremost, thanks so much for having me today. I'm excited about our chat. And I think, to your point, it is very timely. My name, as you've mentioned, is Ashley Brown. I'm a partner at the law firm Filion, Wakely, Thorup, Angeletti. We call ourselves Filion, or Filion Wakely for short. Our practice is dedicated exclusively to anything workplace law related. So labor, employment, human rights, occupational health and safety. And my practice is similarly well-rounded in that respect. And we help employers navigate tricky workplace scenarios. So that's what we and I do.
And Ashley, one of the things I would say about you is you have such a calming effect. Even when you were talking about really complex issues, you explain them so well and thoroughly. And I just would think if I'm your client, I would feel like, A, I'm in very good hands, but you have that, I think you probably do have that effect on your clients as well. And it's important because a lot of these conversations can be very, very stressful.
Yeah, they can be stressful situations, and we do try to sort of temper that for everybody who's involved, right?
Yeah. Yeah. So I have a ton of questions about restructuring and layoffs, but I want to start with the very first question because it came up this morning. And you said it's a timely topic. And I think the reason that it's a timely topic is layoffs happen all year round and people could be listening to this episode at any time of year. It does happen to be it happens to be September, and there are a lot of layoffs that tend to happen. As someone who runs an outplacement company, September through December tend to get busy. Fortunately, towards the Christmas season, things ease off, and I think that is a good for employees as well. But I did have a question come up about laying people off when they're on short-term disability, and I know they're different, so you can talk about the differences, or if they're on a sick leave.
Yeah, no, it's a great question. And it's one that we get posed all the time as counsel. And it's sort of a nuanced answer, I suppose. We cannot terminate or lay somebody off by virtue of the fact or because they are a person with a disability or because they've exercised their right to take a job protected leave. So we can't base or premise our decision making around dismissal or layoff on those sort of protected factors. That said, somebody being away on a disability-related leave or being a person with a disability does not give them any sort of greater job protection than their counterparts in the workplace. So if we are going through a downsizing initiative, a reduction in force in the workplace, it's not as though those folks who are on a disability leave or pregnancy leave, parental leave, have greater job security or protection. They too can be subject to those reduction initiatives. It's simply the case that we can't base our decision making on those inappropriate considerations.
Right. But if what you're saying is if the role, so even if it's like sometimes we have large scale layoffs, I think that's easier to explain. And sometimes we have one role and that person happens to be away either on parental leave. Does it get more complex when it's only one person that we're laying off as part of maybe we're a smaller company?
Yeah, the legal analysis in question is not more complex, but I think the optics around it tend to be more challenging, right? So you're absolutely right that when we have like a large scale initiative where we're eliminating an entire working group from our staff complement, and there are a variety of folks who are up in that initiative, objectively it looks legitimate. Questions may arise when it's a singular person who also, to your point, happens to be on a job protected leave that, is this truly a reduction in force? Is it truly the case that my job is being eliminated from the staff complement? Or does it look like, this person is being let go by virtue of the fact that they are a person with a disability or for some other protected ground or reason? And so the optics around those singular situations, I think, can be more challenging. But in brief, the short answer to your question is that can still be a legitimate reduction in force where we are eliminating that singular role from the staff complement, but it's going to be a more challenging conversation potentially.
Right. Okay, that makes sense. And what you're saying is so important. It's the optics to your other employees. It's also the optics to, a judge if it's put in front of them as well, right?
Absolutely. Yeah. So if you're in that situation, you want to be darn sure that you've got the evidence to support the fact that this is indeed a reduction. We haven't sort of backfilled the role. We've not got a job posting up the next day that suggests that we're hiring somebody new for exactly the same role, albeit under a different job title. All of those sort of surrounding circumstances will be relevant if you find yourself in front of a judge or another adjudicator having to answer for that decision making.
Now, what if, say, you have a larger scale layoff? And what happens if you have roles and we all make mistakes, right? You have roles that you've eliminated, and down the line, maybe a month, 2 months, who knows, you feel like, oh my goodness, I eliminated this role, but we actually need it. It wasn't maybe a profit center for us, so we didn't really see the value of it. But now that we're a few months downstream from this decision, we realize, ooh, we need to hire for this role.
Yeah. And that too comes up with, a fair degree of frequency, particularly in settings or sectors where there's that business volatility, where there's ups and downs in terms of operational need and business demand. So there's nothing problematic, again, about sort of going with those ebbs and flows of operational need and business demand. You can eliminate roles and reintroduce roles. But again, it comes down, I think, to the optics piece of it again, that if it is one of those scenarios where we have let somebody go and it's an individual or a single person who is impacted by that reduction, that they were off on a pregnancy leave, for example, and they've asserted in the meantime that that decision-making on the employer's part was discriminatory and based on the fact that they were a woman, a person who had taken a maternity leave, pregnancy leave, parental leave. It is going to be more challenging to reintroduce that role within the span of a few weeks or months' time. If you're faced with those allegations on the flip side, it's going to be difficult to explain that. So again, you're going to want to be sure that you've got the evidence to back it up to say that there was this sort of market volatility or whatever the case may be that has prompted that change in circumstance.
That's yeah. It's all optics too, right? That we can
is.
never forget that.
Yeah.
What if you're going through a merger acquisition? I'm sure you have clients all the time who go through mergers and acquisitions. There's role duplication. Are there factors that employers need to consider when they're deciding who stays and who goes? So say you have, I'm just giving an example, you have two companies that merge, and you have similar roles in each. Could a company lay off all the people from one company, or how does the rationale work in that situation to mitigate risk to the employer?
Yeah. Well, the biggest risk in those situations is, again, that somebody's going to make that allegation or assertion that they were subject to the downsizing or role elimination by virtue of some protected ground or personal circumstance that would be inappropriate to factor into decision making. So companies and employers that find themselves in that situation, it's going to be really important that you develop sort of an objective criteria or basis as to what it is that you're basing that decision making on. So in your example, yeah, you could say that, all employees who are employed with company A are subject to elimination. That would be sort of an objective, like clear, bright line test. Another consideration that you might consider employing is, okay, it's all the most junior people. So we are going to keep the most senior folks, right, who've got more seniority under their belt and time with the organization. It might be based on skill, experience level. Those sorts of things would be objective criteria that move you away from those risk factors. But we can't simply say we're going to eliminate all the old folks, right?
Right. Okay.
So that's where we really want to get into sort of clear-cut, objective decision-making that mitigates that risk.
And is that something that you would look to someone like you, like your lawyer, to sit down with you and do an assessment of each individual and each role together? Or is that something generally your clients have done once they come to you?
I would say it's a combination of those two scenarios. So depending on where the client is at in their sort of decision-making process, how sophisticated they are, how many times they've been through this process before, Very often we're called upon to provide that advice at the front end when they know that there's sort of this reduction in force that is going to come to pass, and are sort of proactively thinking about, okay, how do we have to plan this out, and what are ways in which we can mitigate that risk from the outset. Those are some of the fun mandates to be involved in, because you're in proactive problem solving strategic mode as opposed to reactive putting out fires mode, right? So good to use some advanced forethought to that at the front end of the process with legal counsel if you can, for sure.
One of the things that we see and that I see dealing with my clients, I'll just bring it up, and you've probably seen it before too, because it goes into the planning process, is that they'll decide to have like senior leadership confirms amongst each other that there's going to be layoffs. They have known all of this for quite some time. And then once they get to the HR department, when we hear new news and difficult news, we go through a process, a change, the whole change management process, where we're at the beginning of the process of denial and all of those awful emotions and feelings. But the people who have been living with this information, the senior leaders, are like, let's just get this done, because they've had to live with it already for months.
Yeah.
They're telling their HR department, and they're wanting their HR department to speed through the next steps. So I would put out a word of caution, whether you're an HR professional who gets this news or whether you're a leader who's planning a restructuring and layoff, to maybe consider the speed at which you move once you break the news to your HR department and start taking definitive action, because a lot of planning and assessment still needs to happen. And maybe you want to bring their opinions to the table as well about maybe not the what, but the how.
Yeah.
And it will make things more smooth for everyone.
Well, I think that's a great point, that very often HR is sort of an afterthought in those decision-making processes. The smoothest, most effective processes that I've seen run have had HR consultancy and input from the get-go, right? So that you've got those considerations, that voice, to your point, at the table when those decisions are being made, so that you can take those sort of key considerations into account as this decision-making is rolling out in real time, and it's not an afterthought. So those are going to be the smoothest transitions for sure.
And no matter the level of an HR professional, they are probably the person who's most likely to have gone through this experience before at another employer that you might have not gone through, even as a senior leader in the organization. So something to consider. Outplacement and career transition support make a real difference for employees experiencing terminations or layoffs. Offering these services also reduces legal and reputational risk for employers. All of First30's outplacement programs include access to a live coach, along with 1 year of access to our career transition portal, job search resources, and much more. Programs start at $985 per participant. You can find information about our programs and pricing at first30ready.com/outplacement, or reach out to us anytime at info@first30ready.com. We know that constructive dismissal can be an issue, but there's some times when we actually need to restructure a role. And that is part of the entire restructuring process. What are some of the implications that employers should think about when they're actually restructuring a specific role? Maybe they want to keep the individual who is in that role currently, or a similar role currently. What kind of considerations do they have to keep in mind?
Yeah. So we can absolutely change a role, right? We don't have to remove the individual from the position itself, but perhaps the position needs some fundamental alterations to duties and responsibilities that are assigned, hours of work, or even compensation levels, right? And we can make those changes. But to your point, the key risk is going to be, are we going to trigger a constructive dismissal by doing that? And so where it is the employer who is unilaterally implementing those changes, and where they are changes of significant or of some degree of magnitude, that is going to potentially trigger a constructive dismissal. And so the way to
Mhm.
mitigate that risk is to get the employee's consent or agreement to the changes that we're looking to implement. And sometimes that does happen, right? Where we've got somebody who no longer wants to work a 40-hour work week. They are absolutely content to take a reduced work week and corresponding compensation cut, right? In other scenarios, that's not something that the individual is keen to accept and will push back against. And so we can either look to mitigate that risk by getting their consent and agreement to the changes, or alternatively, providing advanced working notice to the implementation of the change. And so that advanced working notice is you're going to want it to be sort of in keeping with the amount of notice that you would give them, just as if you were going to issue a termination notice. So we're giving them advanced working notice consistent with what their termination entitlements would be to mitigate fully that risk would be the ideal scenario.
So I have a question about when what you said just kind of made me think of something we've written about at First 30. We call it there's two different types of approaches. I would say kind of the soft glove approach to layoffs and terminations when you're doing a mass restructuring. And I called it the amputation approach, so the difference being, as what it sounds like, the soft gloves approach is when you give people working notice, they're still in the business for 4 or 5 weeks, maybe I'm making up a number, 4 or 5 weeks, and then they get to say their goodbyes. You start them on their outplacement, which hopefully you've provided to them. But you give them permission to start looking for another job overtly, right? And then there is I've been through both myself, actually, one at one organization and one at another.
Yeah.
The amputation approach, where you take someone, you get security to walk them to their desk, they pack up, you take their card, you take their laptop, and they have to pack everything up and they're exited out of the door. I have seen sometimes it's required that you take the amputation approach. So I'm not suggesting that all companies have the luxury to do it this way. I find the soft gloves approach, just from my experience working with clients and my personal experience, so much more humane. The employees who are left behind have such a more, it's not as traumatic for them.
Yeah.
But I'd love your take as a lawyer, what you see work well, or if you think, Amy, you're crazy. The soft gloves approach just simply is it's not acceptable, and it's not something employers should do.
I don't think you're crazy. And
Okay.
also, I love the phrase the amputation approach, and I'm going to adopt that if you're okay with that.
Sure,
Taking
of
that.
course.
I think that both strategies work. But in my usual advice to clients is that you want to give careful thought and consideration to the personality of the individual who's on the other side of that decision, right? So are they the sort of individual who is going to be able to sort of pull themselves together and accept that this has come to pass, and that when we're giving them a period of working notice is usually what we would say the sort of softer approach is, that you're going to work through this notice period and you have some grace and the flexibility to hold yourself out as continuing to be employed by the company. You take this time with our support to try and find alternate employment. Is the person who's on the receiving end of that news going to be able to sort of do that in a way that is still effective and productive and helpful to the rest of their colleagues who are going to be watching this all play out in real time? And some people are absolutely capable of doing that and are very appreciative of that opportunity. And other times there are personalities or circumstances where the relationship is already so fundamentally, I think, broken that just doesn't, it's not an effective strategy, right? And that individual, upon receiving that news, becomes a bit of a poison pill in the workplace and is actually more upsetting to morale and culture and productivity, that it is better to take that amputation approach and just sort of cut ties quickly, and it makes it less painful, I think, for everybody involved. So both can be effective and I think humane, just depending on all of the surrounding circumstances.
Yes, yes. I've seen exactly what you're talking about, where you do have a person that's a poison pill, and
Yeah.
they actually ultimately were walked out. And everyone else, of course, stayed. But that person was working kind of against that I thought very good judgment of the organization to run the layoff in that way. Um, We often see with outplacement. So for anyone who doesn't know what outplacement or career transition support is, it's when you have a company like First30 help your employees who have been impacted by a layoff or termination recover from the job loss and get back to work. Okay. So we often will see clients kind of use outplacement as a carrot to sign their agreement with their separation agreement with the organization. What are your thoughts on when a company should allow an individual to engage with their outplacement? Do you recommend they do it before they have signed their severance agreement, or do you suggest that they have them do it uh, only after they've returned their agreement?
Yeah, it's a great question, and it's one that I get quite frequently too from clients who are looking to structure severance packages and put together those offers. I think you can do it either way, right? Like you can build the outplacement service offering in as part of your severance package offer and make it contingent or conditional on the individual's execution of that release and indemnity that we want back. But my own personal view is that it can be more effective, more humane, and I think you just signal that the employer is acting in good faith and genuinely wants this person to transition smoothly, land on their feet elsewhere, and find alternate employment, to hive off the offer of outplacement services and have that sit outside of the offer. So that it's not conditional on their execution of a release and indemnity. So yes, we've put together this gratuitous package for you. That is conditional on your execution of this release, but separate and apart from that, and with a view to helping you transition smoothly, we're prepared to provide you with outplacement. And I think that is a genuine showing of just sort of good faith on the employer's part. And ultimately, it's in everybody's best interest that the individual land on their feet somewhere else quickly and as quickly as possible, right? And outplacement is tremendously helpful with facilitating that outcome for everybody involved. So
Thanks. It's hard for me to be objective. Obviously, I run an outplacement company, so I have very strong opinions. I will say, though, we see, especially with our participants that have coach access to a coach,
yeah,
because we have different programs for different price points. But when we've seen, we don't really take accountability or responsibility for the de-escalation. We do not talk anything legal with our participants at all, but we just naturally see a de-escalation when they come to us. They can come to us very emotional and upset, some not all by any means, but we see just the process of getting great support does really help them to de-escalate and get a moving forward mindset. So I'm glad we agree. I don't want to give people bad advice that seems like it's in our best interest, but I truly see the benefit of the type of work that we do and what it contributes both to the exiting employee and to the employer.
I agree entirely. Yeah.
Yeah, we could do a whole episode on contracts.
Right.
Terminate. So I think it's too big a subject to get into, but I wanted to know, is there any glaring mistakes? I'm going to say the first mistake that you see companies make with these agreements, not not using a lawyer, trying to use now AI. It's a huge mistake. AI, and U.S. companies trying to lay people off in the same way you would. And I've worked for a few companies that were U.S. based over the course of my corporate career, and it was always they took our opinion, but they were prepared to run the exits in one way, and we sort of pushed back and we're like, hey, Canada's different. But so those are some of the mistakes: not engaging a lawyer, trying to use AI because AI pulls from several different sources that may not be part of your jurisdiction. It looks great on paper, but if you put it in front of a judge, you're going to be in trouble. So definitely call your lawyer, call Ashley if you need help with a contract. But what are some other mistakes? Is there more that are just sort of quick ones that you see happen often?
Yeah. And when you say contracts, you mean like termination letters and release contracts?
Yes, I'm probably using the wrong
No,
terminology.
you're
Yeah.
not. That's so I guess one of the most common mistakes that I see people make is in terms of calculating people's entitlements upon termination. So depending on which jurisdiction you as an employer operate in, There are going to be different, entitlements that somebody may have upon termination. The Employment Standards Act in Ontario sets the floor, right? So the bare minimums of what employees are entitled to in the event of termination. And here in Ontario, we have advanced notice or termination pay requirements or entitlements. But we also have a separate severance pay entitlement. And so one thing that folks often overlook or miss is that when, I guess the severance threshold is triggered when somebody has been employed by an employer for 5 or more years, and that employer has a payroll of 2.5 million globally or more. And so when we are calculating whether that the employee who's subject to dismissal has an entitlement to severance pay under the statute, we have to factor in their total period of employment. And the period of notice to which they're entitled under the Employment Standards Act factors into that. So if we are terminating somebody, by way of example, who's just on the cusp of getting to that sort of 5-year mark, and their 2-week notice period under the Employment Standards Act would push them over that 5-year threshold, they would then also be entitled to severance. And so folks often miss that or miscalculate the severance entitlement. And so as an employer, it's critically important that when you are, in any situation, that you're meeting your minimum statutory obligations for employees. But that holds true also in the termination setting. So you don't want to find yourself in front of a court saying that we failed as the employer to meet our minimum statutory obligations when we are exiting somebody from employment. Paying careful attention to how those are calculated, critically important.
Yes, and I don't think it matters. We always talk, and I say this, I feel like every episode, that 25 is a magic number of employees. That doesn't factor in when you're thinking of these types of agreements, right? So no matter if you're a company of 2 people or a company of 8,000, you still have to take all of these things into consideration, correct?
That's right. Yeah.
Yeah. Okay. All right. So I want to add, we're going to do our little spill the tea, Ashley, because I really want to hear your story. But I also want to note, as always, Ashley's information will be in the show notes. So if you do need actual, like we talk about at the beginning of the show, as in the introduction, this isn't legal advice. It's insight. But if you need an actual legal opinion or you're looking for a lawyer, we'll make sure that, Ashley, your information is in the show notes as well.
Great.
If you want a lawyer to keep you calm and have all the information you need, Ashley is a wonderful choice as a lawyer. Anyway, so Ashley, for anyone joining who's new, we do a little spill the tea segment at the end. And so Ashley, why don't you tell us a story that maybe would be surprising, shocking? We don't, of course, I know you wouldn't reveal any details or anything, but what do you have to share with us today?
I guess one of the more interesting sort of termination scenarios that I've encountered recently, and is in keeping with our sort of theme of today in terms of mass termination or group terminations, was helping a client with a similar scenario where they had gone through a fairly large-scale reduction in force and had inadvertently sent a termination letter to one of their key employees who they had every intention of retaining, but this individual received a notice of termination that contained a severance package offer. The individual received that, signed off on the package, so fully accepted the offer of severance. And I get a call from them the very next day to say, oh my gosh, this individual was wrapped up in this. We didn't mean to terminate their employment, but they've received this notice and in fact have accepted this very generous severance package offer, but they're a key player on our team and we need them back at work tomorrow. In the end, this all worked out fine for this particular employer. They were able to call the individual who understood, was willing to sort of return to work and happy to come back and continue to support. But in that scenario, they did end up paying that individual their full severance package and then issuing a separate contract to sort of welcome them back to, allay any hard feelings and ill will that may have been generated as part of that mishap. So I guess key lesson learned in that scenario is you want to be really cautious and double, triple check, the names and information on these letters that you're sending out before you hit go or hit send.
And we were that is such a great story and word of caution. And we were talking earlier, remember, about that whole change process. I was talking about how people are feeling, but also that is just exactly the type of thing that can happen when we try to move too fast. The last thing I would say on this is you got it in my mind that sometimes your top talent, when they get sort of a sense, your top talent is going to get a sense there's a layoff coming. They're not your top talent for no reason. Generally, they have a good sense. Well, in a lot of cases, I shouldn't say all, they'll have a good sense of what's going on in the organization. If they think for too long that they might be at risk and they don't have any certainty that they're not going to be part of this layoff, they're probably the ones who are going to be most likely to leave, you know, they or think about leaving or start interviewing. So the risk is very high of losing those people if we drag our heels for too long. So there's definitely a balance. But you made me think of that. This person wouldn't have even been thinking about leaving. They get the severance package. They might have started the interview process, and who knows how much longer the organization will be able to even keep them.
Yeah, exactly.
Yeah.
It may not
Yeah.
have panned out as it did in that particular scenario, right? Could have gone very differently, but
Wow, expensive mistake.
indeed. Yeah.
Yes, yeah. Well, Ashley, this has been fantastic. I'm obviously quite interested in this topic, but there's always so many questions everywhere about terminations, and it's like the thing you can't, and layoffs, and it's something you can't. You're afraid to overtly put a message out on LinkedIn to ask for information because you don't want to give that signal to the rest of your business that something's happening. So I'm so glad we were able to have this conversation. I really appreciate you joining me, and I just think the world of you. I'm sure everyone sees exactly what I saw when I saw you give your presentation. So thank you, Ashley, but also thank you everyone for joining us today. I hope this helps you if you are kind of managing terminations or layoffs. But with that, I will sign off and wish you all a really great rest of your day.